This is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Top of the morning, Dan and Amy. President Trump made the big announcement in prime time yesterday. It's going to be Judge Brett Kavanaugh.
In keeping with President Reagan's legacy, I do not ask about a nominee's personal opinions. What matters is not a judge's political views, but whether they can set aside those views to do what the law and the Constitution require. I am pleased to say that I have found, without doubt, such a person. Tonight, it is my honor and privilege to announce that I will nominate Judge Brett Kavanaugh to the United States Supreme Court.
And I think what you will learn from even a cursory review of Kavanaugh's record is that he is the rare combination of originalist philosophy, intellectual prowess, academic credentials, and then what you saw last night when he was announced, political savvy.
Oh, yeah. I mean, he
combination of all of those things.
He made us like him. I mean, he was likable on a number of levels. He's philanthropic. He, feeds the homeless through Catholic charities. He's a coach. He's a great dad. His daughters genuinely seem to love their father.
It was him spinning the personal narrative for people who don't know him, which is virtually everybody outside the Beltway, and for the press, and to inform his conversation with the senators, and ultimately to inform the brutal confirmation he is going to go through with those senators. So talking about his parents, that, he may be some white bread kid from a successful professional family, but he learned some things along the way, including from his parents.
I was lucky. My mom was a teacher. In the 1960s and 70s, she taught history at two largely African-American public high schools in Washington, D.C., McKinley Tech and H.D. Woodson. Her example taught me the importance of equality for all Americans.
And then his mom was a trailblazer in the law.
One of the few women prosecutors of that time, she overcame barriers and became a trial judge. The president introduced me tonight as Judge Kavanaugh, but to me, that title will always belong to my mom.
I mean, stop it. I'm crying over here, honestly.
And then again,
it touched women's hearts. Honestly.
No, I mean, and you want to know about the guy. People want to know about him. So there's nothing wrong with that. That's who he is. That's who his family is. That's great.
And he made the point that he said that, when he was in charge, he hired mostly law clerks who were women.
Right. Another kind of political sop, as was this, the invocation of another Supreme Court justice.
For the past 11 years, I've taught hundreds of students, primarily at Harvard Law School. I teach that the Constitution's separation of powers protects individual liberty. And I remain grateful to the dean who hired me, Justice Elena Kagan.
Ooh, zing. And then lastly, how he captured your vote, Senator Jacobson, was his prowess when it comes to coaching girls basketball.
For the past 7 years, I have coached my daughter's basketball teams. The girls on the team call me Coach K.
That's awesome.
See what he did there?
Yeah.
Or the
that's
girls
what they
did?
call him. I mean, and he went on to say that they won the city championship this year.
There's no question.
CYO basketball. I mean, I hope he continues to coach. You think maybe he'll be busy?
He's going to have a full docket, but
maybe the summer months he could do it.
See if he can't work it in. Maybe have some of his clerks as assistant coaches. For more on this topic, we're pleased to be joined again by Randy Barnett, who's a Georgetown law professor, by way of Chicago, we should add. Also the author of the book, Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. Randy, thanks for joining us again. Appreciate it.
Good morning, Dan. Good morning, Amy.
Well, one of the things that you have said, we've talked to you about a number of justices and the run-up to the selection of the nominees before. One of the things you've said, if you were counseling presidents, is pick somebody with a record. Don't play the politician's game. Let's pick somebody who has no record so that nobody will know. Actually, pick somebody with a record so you do have an indication of what their judicial philosophy is. And President Trump did that by selecting Brett Kavanaugh, didn't he?
Yes, I think that's what gave him the edge inside the process over other very appealing and attractive judges who did not have a long judicial record or whose record of decision-making didn't really apply to cases of the kind that would reveal their judicial philosophy. So I think that is one of the things that gave him a huge edge in this process.
Some those on the left, Chuck Schumer, said they have a problem with, in one of his decisions, he talked about presidents should be shielded from litigation while in office. They see that as a way of him, protecting President Trump. Do you think that is going to come up during his confirmation hearings?
Oh, sure. And that was an opinion that he gave before he was a judge, I think, actually, as I recall. He's got the problem with a really long record like this is that you got a lot of stuff to try to learn and keep in mind, including his tenure when he worked in the Bush administration White House, his tenure when he worked for Ken Starr as this special prosecutor, and then his tenure as a judge. So there's a lot there, and there's going to be a lot of muckraking through all of that stuff, and the document review process is going to be very, very challenging for the Republicans to decide, and for the administration to have to review documents and decide what can be turned over and what's executive privileged and can't be turned over. That's going to be one of the downsides or the cost of this particular pick.
But again, going back to the upsides, you've got case law that is on point on a number of issues that are important with respect to the legislative process, important to the American people. He has held forth on Second Amendment individual right to self-protection in the Heller case and the extension of it. He has dissented from a majority opinion on the issue of immigration with respect specifically to H-1B visas. He has weighed in on religious liberty. He's weighed in to some extent on Obamacare. So there is sort of clear lines that have been drawn, also clear instances of judicial restraint, even where perhaps some conservatives would have wanted him to go further in a particular case, like the Obamacare-related case. And he didn't because he didn't believe the case was ripe for adjudication at his level. So there is a lot there for conservatives to rally around, even though he's seen as sort of an inside-the-beltway player.
Yeah, I agree with you about all those cases except what you say about his Obamacare decision, where I just, I was there and I heard oral argument in that case and heard him at oral argument in that case. And I really, really strongly disagreed with his opinion. And that was one of the things that that opinion, I think, is one of the reasons why he was not on the original Trump list. He was added later when they supplemented the list after the election. They added 5 judges, and he was one of them. And the thought was they added 5 judges so that he would be one of them. And I think he was not on the original list because of that Obamacare decision. It really was pretty bad. But look, he's got a very long record. You can't be judged entirely on the basis of one decision. And what's going to happen now is going to be political theater, because the Democrats have already made it clear, and their interest groups have already made it clear, that they would oppose any justice, any judge that President Trump would pick, in much the same way that the Republicans would oppose any judge that Obama picked in the last year of his presidency, which is why they didn't hold any hearings, because hearings would have been superfluous. They wouldn't have been about Merrick Garland at all. Anything that was said about Merrick Garland at such a hearing would have been a pretext. It wouldn't have been what was really going on. Now we're going to hear a lot of pretextual arguments about Brett Kavanaugh that won't be what's really going on, and what's really going on is denying Trump any additional Supreme Court justices.
Right. Now, I just want to go back to this Obamacare decision, because this is being kicked around by proponents of Kavanaugh as well as opponents of him, including the American Family Association came out and suggested conservatives oppose Kavanaugh's nomination because of that case and because they didn't feel he went far enough in the Priests for Life case. And I disagree with them on that. One of the arguments that was made in a piece in the Federalist by a former clerk of Kavanaugh's is that his dissent in the Obamacare case, the mandate case, his dissent from Judge Silberman's majority opinion was still included language that the individual mandate, Obamacare, a law that is unprecedented at the federal level in American history, jarring prospect, would usher in a significant expansion of congressional authority with no obvious principal limit. So that's not exactly a defense of Obamacare, the individual mandate. That was an argument that it should be brought in the future until it was imposed, right?
I think I read that Federalist piece. That was an unduly puffed piece about Kavanaugh's opinion. I don't think it fairly reflects what Kavanaugh was doing in that opinion.
Okay.
At that part of the opinion, Kavanaugh said that the law had, if it had any constitutional defects at all, he said under the tax power, they were relatively minor and would be quite easy for Congress to fix. Then he proposed 3 different ways that Congress could fix the law very easily to make the individual mandate a constitutional tax. He didn't say it was a constitutional tax, but he said it was very close to being a constitutional tax. He did not say it wasn't a constitutional tax. And that's actually somewhat like what Justice Roberts did.
Right.
Justice Roberts ruled that because it was unconstitutional under the Commerce Power, it could still be construed as a tax. It was a reasonable construction to construe it as a tax, and therefore it might be construed that way. That's very close to what Brett Kavanaugh did in his. It's not exactly what he did, but it's very close to what he did.
Yeah,
and then he found in the bulk of his dissent is that it was a tax for purposes of the Anti-Injunction Act. Now that's technical because courts have held that a tax could be a tax for purposes of that statute and still not be a tax for purposes of the Constitution. Ultimately, that's what the Supreme Court. It didn't exactly say that in this case, but so he didn't call it a tax for purposes of the Constitution, but he came very, very close to providing John Roberts the roadmap to the roadmap to what he actually did.
Yeah. Okay. Well, that's a fair criticism. I mean, now Roberts made an argument that even Obama's lawyers didn't make. The federal government's lawyers didn't even make in terms of manufacturing this into a tax. But you're suggesting that the thinking that was presented by Kavanaugh could have easily informed Roberts to take that final step.
Well, actually, I have to disagree again. I think Don Verrilli at oral argument, which is you're going to be forgiven for not knowing everything that was said in 8 hours of oral argument, Dan. But I think Don Verrilli in oral argument did try to provide Obama this out. I mean, try to provide John Roberts this out.
Wasn't he arguing the alternative though? That wasn't the first offering they made, and then it was arguing this as another possibility.
Yeah, but that's all Roberts found. Roberts said the natural reading of the statute was that it was a penalty enforcing a requirement, therefore it was a mandate, and that would be unconstitutional. He should have stopped there.
Right.
He should have said that's the natural reading of the statute. It's unconstitutional. We stopped there. But he said a reasonably possible reading of the statute is that it was a tax because the amount at issue was not coercive, and that's something else that Judge Kavanaugh did mention in oral argument in the Seven Sky case. So because it was reasonably possible he could read it that way, that's the move Roberts made. Kavanaugh did not make that move. That was not his move. But that was Roberts' move, and that's how he got out. That's how he could both say it was unconstitutional under the Commerce Power and still uphold the law.
Oh, okay. No, all right. I just wanted to elucidate because this is a huge case, and as you point out, it could have been one of the things that was initially keeping Kavanaugh off the Leonard Leo et al. List, and so this is something that he may get questions on from conservatives, even though the focus, of course, is going to be the left coming at him over Roe v. Wade and things like that.
Yeah, but he's going to have answers that'll satisfy the senators. So everything that happens now is going to be theater. Senators don't ask real questions anymore.
Right.
It's too bad they didn't figure out how to answer. They don't listen to what the answers are. By and large, they're getting ready to ask their next question that staff has prepared for them. I wish that weren't the case. I've written articles about how the confirmation process can be improved by both sides, but I don't think that's going to happen this time around.
Well, what's your biggest recommendation? I mean, I know they're dog and pony shows, and I feel like the senators are just self-absorbed and want to make a name for themselves.
My biggest recommendation is they should stop asking about whether cases are right or wrong. The cases they like or the cases they hate are rightly or wrongly decided, and start asking nominees to explain to them how they understand particular clauses, what particular clauses mean in the Constitution, and that might reveal how they approach constitutional interpretation, which is what I think is a very important judicial qualification, is that their view of what how to interpret the Constitution as part of your qualifications to be a judge.
Well, that's not as much fun as asking, why do you hate women, you see. So here, the other thing I want to get from you, though, is looking at this record of Kavanaugh's. I mean, do you feel comfortable making a guess as to whether he's going to be more like a Alito or Scalia, or more like a Kennedy?
Look, I think all that I'm prepared to say is that he's replacing Justice Kennedy. And so his replacing Justice Kennedy, based on his record, is going to move the court in relative to where it is today, or in a originalist and textualist direction, because he is far more textualist and originalist than Justice Kennedy was, the person he's replacing. So that means overall the court will be moved in an originalist or textualist direction. Whether he ends up being more like John Roberts, which is also a possibility, or more like Justice Gorsuch, who he co-clerked with the same year at the court with Justice Kennedy, that I think is something that we're not going to find that out in the hearings, and we're only going to find that out once he gets on the high court. From
his record in terms of advancing originalist judicial philosophy, would you say that his holdings in cases involving the administrative state may be the best expressions of his commitment to originalism?
May or may not be a commitment to originalism. It's a commitment to what you might call the structural constitution, the separation of powers. He has a clear commitment to separation of powers, whether informed by originalism or not. He does have stuff like the Second Amendment case, the Heller II case, that is an originalist opinion. So I'm not saying he doesn't have any evidence of that.
Right.
But you can be informed by principles like separation of powers without being an originalist. He seems very interested in, very committed to that. And I think the big draw to the White House really was his consistent harping on separation of powers and against the administrative state. That is what I think made him so appealing, that he overcame objections made against him of the kind we've already been discussing.
Okay. He is Randy Barnett, Georgetown law professor, author of the book Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. Professor Barnett, thanks as always for joining us. Appreciate it.
It's always a pleasure with you guys.
Thank you.
Thank you. And he joined us on our turnkey.pro answer line.